Hello and welcome to the Dental Chair. I am your host, Marguerite Morgan. I am the founder and director of Irish Dental Jobs. With 25 years recruitment experience in the legal and dental arena, I tend to do things very differently, and I wanted to showcase how we establish and maintain relationships to help match the right people to dental practices nationwide. On each episode, before each episode, we're going to touch on one or two key insights from our recently launched salary guide. And to discuss these with me, to my right, is my right-hand woman, Margaret Kierans. Margaret has been working with me for the last 6 years. She's the marketing manager at Irish Dental Jobs, and she is the master behind our Dental Insights and Trends brochure. So, Margaret, what key insight have you got for me this week?
Well, this week I've decided to mix it up a bit.
Okay.
So,
interesting.
Yes, it is interesting. I am going to touch on our phrase, people matter. So, I don't want to give too much away on the salary guide insights, which is why I changed it up. We have touched on retention. So, I'm going to talk about what comes before retention, recruitment. It dawned on me when I was reading through the brochure. And I just seen people matter. And I was like, I know where it comes from. I know it comes from, you have a genuine interest and care for people that come to you. But I actually have never asked, where did that originate? Where is there a story behind it? Why you chose that as your tagline for the last 15 years?
Well, people do matter to me. I'm interested in people. I'm very interested in people's story, and I genuinely care about people, whether it's on a personal level or on a professional level. And in recruitment, I know what I do is very different because I get very involved with people, and it's the only way I can do it, because when I have an idea of what's going on in their lives, that really helps me to find the right practice for them on a long-term basis. And in recruitment as well, I just always, it's not just recruitment, but it's in all walks of life, that everyone that I meet or cross paths with, that I always want them to feel that they can always come to me no matter what. And that really works, like I said, in the recruitment side of things, because I know most people do feel they can come to me and it just works. But, I suppose why I really, make sure that it's seen and heard is 15 years ago, when I was in the process of setting up Irish Dental Jobs, I went up to visit Dr. Tony Connellan, Dr. Anthony Connellan. He ran a practice for many years in Rathmines. Dr. Jamie Maguire now runs that practice, actually talking about connections as well. It always surprises me, all the connections we make that aren't directly connected with dental, but we are, because I used to hang around with Tony's son. Mm-hmm. When we were younger. But anyway, so myself and Tony, we went for lunch, and I obviously had a flyer or something with me at the time, and I had people matter. And he said to me, what a fabulous statement. And he said, that just says so much about your personality. And he said, promise me going forward that everyone sees it and hears it. And basically, I took his words on board. But it is my ethos anyway. People do matter. But I took his words and just, here we are.
All right, Mother Teresa.
Oh, you're so funny. You're so funny, Margaret.
No, honestly, I do. I see it myself in the office. Like, it's not just a mere tagline. Like, it is a matter of fact. Like, when you're on the phone to candidates or even clients, like, you speak to them as if they're your family member. Like, it is a profession on a professional basis, but it's also on a personal basis. Like, you do go way over and above for everybody that comes to us, and probably a bit too involved nearly. It's so much more than just, interviews, CVs, recruitment. Like, it's always, you get down on a human level with people, and it's...
You looking for a salary increase?
Well, you've already given me one this year, but I won't say no to a second one. But I know myself working with you that, I choose my own days. Like, you should be saying, Margaret, these are your days I want you to work. Where I come in and I say, Marguerite, these are the days I can work, and you say that's fine. Like, or when the kids are sick, or I need to come in early or come in late, or whatever needs I have on a personal basis, you always have no problem with them. And any problems I have, I come into work, personal or professional, I always feel like I can approach you, and I never feel like I can't come in and say something to you. Don't want to make your head too big. But yeah, no, it is not just a mere tagline. It is factual, and
thanks so much.
Right, I won't build her up too much, but yeah. So back to salaries. On a more serious note, I do want to say, if you do want to order your salary guide, we are the first organisation in the country to publicise a comprehensive guide in salaries in dental. We're the only dental recruitment agency in the country. We have 15 years experience behind us, which means we have 15 years of salary data. If you do want to get your hands on a shiny hard copy, you can do so at irishdentaljobs.ie/salary guide. And just so you are aware, it is commission based, so I get 10% of every copy.
And now, on this week's episode, we're going to delve into the topic of employment law. We've actually sparked a lot of interest amongst our clients and candidates in this episode in particular. And joining me on the dental chair this week to discuss this topic is John Lynch, partner at Whitney Moore Solicitors, a top 20 law firm in Dublin. John, you're very welcome.
Hello, Marguerite. Thank you very much for having me on today.
It's been a long time, actually. We know each other a long time.
We do.
It's hard to believe that you are actually my very first client visit when I was in legal recruitment.
That's right. And back in those days, you looked after us and helped us in all our recruiting needs. But then you went on and set up Irish Dental Jobs changed sector and have made a great success of that business.
Yeah, and I think when I was working with you as well, you were the managing partner at Whitney Moore, and you were the managing partner up until this year.
Up until last December. I finished my term last December. So back to the nuts and bolts of the job now and looking after client needs.
And just with regards being a manager or partner of a law firm, I'd imagine, that carries a lot of responsibility and hugely stressful. In your role as a managing partner, is it your responsibility to oversee all the employees?
As managing partner, you oversee everything. Whitney Moore is a full-service law firm. We provide property services, dispute resolution, employment, corporate services. But each team would have a team.
Right.
Or each team would have a head or a partner who is in charge of that team. So I work with all of those, and we used to work with all of those as managing partner to make sure that the needs of the business were fully met.
How many would that be approximately?
We have a team in total of about 65 people. We have about 35 lawyers.
And you're managing 65 employees.
I was at that stage.
Oh, God. So I'd imagine this year life is very different.
It's very different. And as managing partner, by necessity, you do less client work and more managing of the business. So this year I've been able to go back to what I like best, which is
actually, I was just going to ask you that, right? Because, I've been running a company for 15 years, and like what I enjoy and what I'm really, really good at is recruitment. Mm-hmm. But, I'm trying to run a company for the country. So you're pulled in all directions. So I'm probably only getting to do maybe 25-30% of recruitment. So you're in a situation where you're back doing what you love.
It's a very similar sort of situation. I think anybody in professional services probably recognise it. I'm sure your dental clients recognise it when they're running their own business. A part of the business is, in my business, the law, the clients, looking after the client needs. But a part of the business, an important part of the business, is looking after the staff and making sure that everything is in place to allow the solicitors in our team to do their job. So it's just part of the management and the organisation of it.
Very good. And we also have a second connection.
We do.
I only learned, it was after a few years of working with me that I only learned that you are the husband of our wonderful superstar head nurse, Claire Lynch.
And I'm very lucky to say she's my wife, indeed.
I'm sure you'd agree she is a superstar.
She is a superstar. I tell her that all the time.
Oh, very good. In all seriousness, the reason why I thought it was fitting to have someone like you on one of our episodes is because in Ireland, to qualify as a dentist, it takes 5 years to qualify as a dentist, and over that qualification process there are few or no business related modules. And as a result, many dental practitioners may lack sufficient knowledge of employment law matters. You know, often there is little support, so practitioners may not be up to date with their employment responsibilities. So you might, you know, give a brief outline of some key factors that for practice owners that will guide or ensure that they comply with employment law matters in Ireland.
Marguerite, I used to do a training session with trainee GPs shortly before they qualified as GPs.
Okay.
And I would spend a day with them talking about medical practices, because these would all be students, but in time would hope to run their own medical practices. And I think there's a clear analogy with a dental practice. And one of the pieces of advice I would always have given them was there are two key relationships for somebody, particularly a professional service provider, who is going to set up their own business in due course. And I think those two key relationships are have a good relationship with an accountant and have a good relationship with your lawyer. And I think those are, if you can develop the right relationships there, they will stand to your credit all the way through your career. And they will also give you somebody to use as a sounding board who has experience and who will be able to help you, whatever the issue, the question, or the problem might be. So as a basic, that was always one of my tips and one of my pieces of advice. Develop those two good relationships.
Okay.
So that you have somebody that you can pick up the phone to and say, look, can I bounce something off you? Can I ask you a question? Can I meet you for a cup of coffee? In terms of employment law, and I've been doing employment law now for best part of 30 years, there's a lot of information out there. And obviously one has to be careful about the information on Google. It's not the best place to get advice, but basic information, that it is out there. What I would say to every employer, and particularly small to medium-sized employers, and we do a lot of work in that area, is get your fundamentals right, get your setup right. And in the employment context, what that means is get your contract right and get your handbook right. Because everything will come back to the contract and the handbook. The amount of times when people will ask me, what do I need to do here? What will I do? How do I handle this situation? I say, well, what does the contract say? Let's have a look at the contract. Let's have a look at the handbook. What do the policies say about what it might be a question about maternity leave. It might be a question about holidays. Might be somebody wants to take extended leave or wants to travel the world for a year. So often you can go back to the contracts, go back to the handbooks, and that is your starting point for dealing with most of the situations that arise. So I would encourage every employer, small to medium size in particular, because you go to a larger enterprise, they'll have a HR department, but a small to medium size, the difficulty of a small to medium sized business owner is you're a bit of a jack of all trades. You're supposed to be on top of everything. That is an area where it is worth investing a bit of time and effort, getting some good advice. Get your contracts right, get your handbook right. And once they're up and running, it's worth getting them reviewed every 3 years, 4 years.
Yeah, that's what I was going to ask, because like for me as a small business owner, and I'm trying to run a company for the country, I'm also, the primary recruitment consultant in the business. Like, I learned a long time ago how important it is to have your house in order. But like, I don't know, like, how do I know if there is new employment legislation and I don't have the time to check that. But if you do update your contracts and your employment handbook every 3 to 4 years, you should be okay.
You will be on top of it. And if there are major changes in employment, they'll be well flagged in the media and you'll hear about it.
I still probably wouldn't.
Well, most of the changes that come along are tweaks to what's there. And that's why if you do your handbook, you get it reviewed every 3 to 4 years and just get it brought up to date.
Yeah.
And if you have a relationship with, for example, a lawyer, we will often send out newsletters and briefing notes to clients just to let them know this has changed.
Okay.
And it may be in the employment sector, maybe the property sector, it may be in any sector at all, but we will do those periodic updates to clients.
You've just given me an idea there. I'm just going to speak out loud, just for something you said there, that you used to do seminars for GPs. maybe that's something we could possibly offer to the dental profession.
Yeah.
So, because I've learned over the last 15 years, there is little support there, there is little knowledge there, and maybe we could put it out there to see if employers would be interested in maybe doing a seminar, or even newly qualified dentists who are about to qualify, because I would go out and visit the colleges. So, would that be something you'd be open to?
That's something we do routinely with clients,
right,
and we'll be
okay.
happy to provide and happy to assist with that. Yeah.
Right, okay.
Yeah.
Another idea. And like I mentioned, John, at the beginning, we sparked a lot of interest from both our clients and our candidates. And so we have questions from both parties. So if you don't mind.
I will do my best
thank you very
to
much.
answer them for you, Marguerite.
Okay, so let me see. They're not all, they're kind of mixed with clients and employees, if that's okay.
Perfect.
So number one, what is the legal status of having different roles on different maternity pay agreements? Obviously, the statutory minimum has to be paid. But if, for example, we agree to pay more than that, for example, a dental nurse, but a business couldn't afford to offer same, for example, a dental hygienist due to their higher salary, is it legally acceptable to offer different levels of this to different roles?
That'd be a sort of question that would be fairly typical that a client would ring up and ask. The employer needs to be conscious of the employment equality legislation, and the employment equality legislation provides that you cannot discriminate between employees on the 9 grounds that are set out in the Act. So that's age, race, religion, disability, etc. So people are familiar with the 9. So you may not discriminate in what you pay somebody on any of those grounds. You also have an obligation to treat fixed-term workers like fashion as permanent employees, and
temporary
and part-time workers, exactly,
yeah.
as you know well. So they all have to be treated comparably. You're not entitled to discriminate on those grounds. You are entitled to treat people differently if it's on other grounds. So, for example, people will often be treated. One employee will often get a higher salary because they have a different qualification that is required within the business.
So they would have,
or they have more experience. So
there's
whatever.
2 different qualifications here.
So if there are different qualifications, and if that is the rationale for distinguishing between the employees, well, that is permissible. But you may not distinguish or discriminate on any of the prohibited grounds.
Right. Okay. Thanks.
So the answer is you can treat people differently, but be careful how you do it, because there are circumstances where it's unlawful, and it can also give rise to industrial relations issues as opposed to employment law issues. So you're not breaching any law, but your staff are going to be aggrieved if one person is getting X and the other person isn't.
Right. So just for me to kind of understand what you're saying. So we've 2 different qualifications, and one is like a qualified dental hygienist would be on a higher salary. Mm-hmm. So if it's a different qualification and a role, then you can maybe it would be.
Yeah. So if an employer is trying to recruit an experienced hygienist and is having difficulty recruiting that role, and they made a decision, okay, we're going to enhance the terms of the benefits available for that role to attract an employee, that is something they're entitled to do.
Okay. Now, I'm not sure if this one is for you or whether it's for one of our next guests. It is extremely difficult for a small practice to comply with stringent regulations like the standards of health and safety infection control. Keeping on top of these regulations is so time consuming and also costly, especially for a small practice. It is a job in itself, especially if there are no previous procedures and protocols set in place. From looking online, there is a lack of clear guidance, and there is no effort made by the Council of Ireland to inform dentists of changes to compliances or provide them with assistance in being compliant. Is that relevant?
It's not an employment law question, but it is a regulatory one, and I do a lot of work in that area as well. There is an obligation on every profession, be it solicitors, dentists, doctors, architects, accountants. every profession has a regulatory body, and a regulatory body that sets standards in respect of guidelines, codes of practice. And those are guidelines and codes of practice that are disseminated by the regulatory body, who have those codes of practice up on their website, who provide training courses, etc. It is expected, it is the obligation of the professional, the solicitor, doctor, dentist, accountant, to make themselves aware of that and to ensure that they comply with the required standards. Because what happens if somebody doesn't comply with the standards, and if there's a complaint to the regulatory body, it can end up in a disciplinary against that professional, which nobody wants to be in that situation. And an answer of I didn't know about it is not going to be an acceptable answer. There's the old expression that ignorance of the law is no excuse. So the onus is on the professional, the practice owner, operator, to know the regulations that apply to them. There will also be an onus on them to put in place training for their staff so that their staff are aware of it. And there is no way around that. So people need to engage with their regulatory bodies who issue newsletters and leaflets and guidelines and bulletins and put them up on their website. And there is a requirement that people make the effort to know what regulations apply within their industry.
Very good. If a dentist employed by a practice on a self-employed basis, and this dentist behaves in a manner towards an employee that does not comply with employment law, and it becomes a legal issue, who is at fault? Who is liable? The practice, the dentist, or both?
Yeah, and that can be an issue that arises in the dental sector. It goes back to what we discussed earlier on. Get your fundamentals right. So every employee should have a contract and they should have a handbook. And if a new client comes to me with a question like that, the first thing I'll be asking them is, well, will you show me the contract and let me have a read of that. The contract, there's an obligation on an employer to provide a statement of terms of employment in writing. That statement includes the core terms of the employment relationship and includes the statement of who is the employer. So if I'm the employee, if I have a complaint, my complaint is with my employer.
Yeah.
It's not with an independent third party, it's with my employer. So that's who I have got to engage.
Okay.
If I'm the employer and I have retained on a contractual arrangement as a self-employed person to carry out services, I'll have a separate contractual relationship there to cover that relationship. But as the employee, if I have a complaint, that will be a complaint that I have to raise with my employer. And the handbook that we talked about will have policies and procedures in place. So we'll have a grievance procedure in place. So if I have something that I'm not happy about, if I've been treated badly, if I have something I want to raise, it will set out within that grievance how that should happen. And that would there'll be an informal process. Let's sit down and talk about it and see can we resolve it. And if the informal process doesn't sort it, there will be a mechanism for a more formal process to be gone through.
Okay, very good. Yeah, should there be a delay on your wages? For example, if you get paid on a monthly basis and it is to be paid on a specific date, should it be paid on the specific date? Or like, is it acceptable that, it could be 1 week, 2 weeks later that it doesn't arrive?
I don't think anybody would be happy about expecting to be paid on a date, not getting paid for a week, 2 weeks or 3 weeks later. Again, the contract is the starting point. So the contract will say how much is to be paid and when it is to be paid. So it might be paid weekly, 2 weekly, might be paid monthly. Yeah. If the contract provides for example, a weekly pay, that's a contractual obligation then on the employer to pay weekly.
Okay. The same then on a monthly.
Exactly.
Yeah.
If the contract says it'll be paid monthly, the contractual obligation is to pay it monthly. If in exceptional circumstances, there might be some reason why it's going to be a couple of days late.
Yeah.
I can't imagine it would be any later than that, but in exceptional circumstances.
And if it's something that happens on a regular basis? If
it's something that happens on a regular basis, first of all, I would encourage the employee to see can it be resolved in an informal basis, i.e. the informal grievance process that's in the in the handbook, and they say to the employer, look, what's going on here? I'm due to be paid weekly, and see can they get it sorted. The onus, the obligation is on the employer to sort that out and get it fixed.
Yeah.
If it is consistently happening, it is a breach of the payment. It's a breach of the contract. It's also a breach of the Payment of Wages Act.
Okay.
And it's open for the employee to bring a payment of wages claim before the WRC, which is the Workplace Relations Commission, which deals with employment disputes.
Okay. Yeah, very good.
And I can tell you, an employer will get no sympathy if they are consistently late in paying employees.
Okay. Very good. Thanks very much for that one. Okay. The next question. The only question I have in relation to employment law is wages and the gender pay gap. Is there any way to close it? For instance, I'm working as a dental nurse for 15 years, traditionally a female-dominated profession, yet I'm on €5 an hour less than my partner, who walked onto a building site with a week-old safe pass in his wallet after being a chef for 25 years.
Well, the pay discrimination rules can't and don't deal with different jobs in different sectors. For example, a nurse versus a construction worker. Pay discrimination deals with like pay for like work, and where there are disputes and an employee feels that they should be paid, they're not being paid the appropriate rate, or that they are being discriminated against, they will have to provide a comparator. So the comparator is somebody from their own organisation.
Right,
as opposed to a different organisation.
Yeah.
So one dental practice in Ballsbridge may pay a completely different rate to dental nurses than a dental practice in Arklow, because their overhead would be different and demands would be different and circumstances would be different. The pay discrimination is something that ends up before the WRC, but it's discrimination on the 9 grounds that we talked about before. And where it arises, it's about having the right comparator within the organisation as opposed to a comparator in a completely different industry sector.
Okay, very good. This one actually resonates with me because we actually discussed this previously on another episode. Is it a legal requirement to receive an annual pay rise?
I go back, no, well, rarely.
Right.
It could only be a legal requirement if the contract of employment says you will get a pay rise every year.
Yeah.
And in all my time, I've never seen a contract that says you will
I'd
get
imagine,
a pay rise every year.
You know, like, because we were talking about, like, one of our key insights is that 25% of support staff haven't experienced a pay rise in over a decade. And Margaret, my right-hand woman who worked with me for the last 6 years, you know, asked me the question, you know, is it standard? Because, like, I've given her a pay rise every year. So I could only speak for myself. You know, I would have thought it was standard, because if the economy is stable, if the company is stable and someone comes in every day with a smile on their face, does a hard day's work, like, for me, it's a small token of appreciation. But whether it was standard, I couldn't answer that. So, you know, we said we'll ask the expert.
Whether it's standard or not, I think 10 years is a long time to go without a pay rise. If I put my hat on as a managing partner in a professional services firm who are working hard to retain the good staff that we have, if I want to retain those staff, how they are treated is key to that. And as a practical consideration, if I'm not giving staff pay rises when they have earned those pay rises and they are working hard within the organisation, well, then I'm in danger of losing those staff.
Yeah.
And if I lose them, then I have to go out onto the market to replace them.
Yeah.
And you'd be delighted within your recruitment sector that we have to go and recruit. It's not ideal. You want to when you have good people, you want to retain
you want
those
to look
good people.
after them. You know, that's what I said. That's what I mentioned in one of the last podcasts. I provide staff for a living. You know, to, like, legal for 9 years and dental for 15 years. But I wouldn't want the shoe to be on the other foot.
And look, the reality is, if I have good staff and I don't review their terms with them, give them a work environment in which they're happy, challenged, but enjoying coming to work every day, well, that's only going to, if I don't provide that, that's going to incentivize them to go to the recruiter to say, find me another role.
Yeah.
which isn't in my interest. So to my mind, there are certain procedures that an employer should do on an annual basis, or even 6 monthly or 3 monthly basis. So sit down with their employees, and it need only be a 15-minute conversation.
Yeah.
But look, this is what you're doing well. These are the areas where I think you could do better. A performance review with them. It also affords the employee the opportunity to say, I need training in a particular area, or I want to develop skills in a particular area, or I might want a bit more flexibility. But it promotes discussion and engagement. And I think as part of that whole process, my view, there should be, what contracts will typically provide is the salary with a provision that there will be an annual review. There may not be an increase, because whether there's an increase or not can take into account the financial circumstances of the employer at the time, the market, the performance of the employee, a whole range of those. But that should be a conversation that is had with the employee.
And I think if, like, Dr. Sarah Jane was on one of our episodes, and that's exactly like what both of us agreed, you know, as long as you keep the communication lines open as well, you know, that you have that discussion.
Communication is vital in every relationship. Communication is vital.
Yeah. Okay. And let me see. When an employee has been working with a dental practice for 4 years plus and begins to mix work days, shows a negative attitude, and has minor conflicts with other staff members, what legal advice can be provided to handle this situation appropriately? What steps should a practice take to ensure they are compliant with employment law while addressing these issues? I think this goes back to the handbook and the contract.
It goes back to two things we've just mentioned, the communication. So if you as the employer have a practice of sitting down with your employees on a one-to-one once every 3 months, once every 6 months, that is a conversation that can be had quite simply and in a low-key and informal manner. You've started coming in late, or you don't seem to be in good form, what's going on, and you can try and address it in an informal manner. And then, as you mentioned, the handbook is going to have disciplinary procedures and performance improvement procedures and things like that. So if it hasn't been dealt with informally or hasn't been resolved informally, there will be a procedure there in the handbook, if you have a handbook, that will allow it to be dealt with formally. And ultimately, you need to have that procedure in place. You need to follow that procedure. And that it might ultimately lead to disciplinary procedures. The vast majority of time, it is resolved long before it gets as far as disciplinary procedures.
Okay.
But it's about dealing with the issue early and dealing with it clearly with clear communication. What we often see is issues like that are not dealt with, and they go on and on and on for 3 months, 6 months, 9 months, 12 months. And then when the employer does deal with them, they are major issues, as opposed to something that could have been nipped in the bud quite early.
Yeah.
So my advice on that is always have a conversation early on, see if it can be resolved early. If it's not getting resolved, or if it's escalating, well, then there will be procedures in the handbook that will allow it to be dealt with in a more formal way.
Yeah.
And it's a matter of following those procedures.
Yeah, agreed. And if a patient has received a refund but continues to request to be seen by a dentist in the practice, are we legally obligated to accept this patient again? What guidelines should dental practices follow when dealing with difficult patients, especially in cases where treatment has already been refunded?
Okay. Again, it's not, strictly speaking, it's not an employment question. It's on the regulatory side. And my general advice to professional service providers in a situation like that was tread carefully. Your first port of call will be to have regard to the code of conduct that the professional body has. In this case, the Dental Council Code of Conduct will be on its website. It will have provisions in where that deal with circumstances in which it may be possible, or the procedure to stop treating a patient. In the normal course, to make a decision to stop treating a patient should be a very, very last resort and should be an exceptional circumstance. So long before it gets to that point, there should be clear communication with the patient as to whatever the issue might be. Where I've seen it before is in the context of how the patient treats staff and treats the dentist, etc. So there should be clear communication as to what's acceptable, what isn't acceptable. There might have to be a warning to say, look, if that sort of behaviour is repeated, we may not be able to treat you. There is an expectation in the normal course under the Dental Council Code of Practice, that Code of Conduct, that if you're going to cease to treat a patient, that in consultation with that patient, you will arrange for the patient to go to another dentist. But I would say as a general rule, it should be a last resort. And it would be an area, for example, I would encourage my clients to talk to me before you do it.
Okay. Very good. And this one actually resonates with me as well. What is the difference between a standalone law firm that specialises in employment law versus an organisation that offers 24-hour support legal advice?
In the normal course, legal advice will come from law firms. There are a number of HR consultants and HR companies out there who provide HR support. What we will provide as a law firm, we will provide the employment law advice, the employment law assistance, and there would be quite a degree of overlap. I suppose the advantage in dealing with us is you will deal with a solicitor who's practical, experienced. We like to think we will get back to you quickly. I hope you find over the time that we get back to you quickly and promptly, and with very practical advice. And we also value and think it important that there be consistency in the relationship, so that when you call me, you will get me, or if I'm not there, you know who works with me, and they will get back to you as well. So that sort of consistency, because through that consistency, I get to know your business, and I get to know how you operate your business, and I get to know your staff and how it's structured. And that's
for
an
a small
important part.
business owner, I think that's really important, that you have one person. Like I can't bear, if I have a query and I ring to follow up and I'm talking to a different person and a different person and a different person, I don't have the time for it, and I get very, very frustrated. So for a small business owner to have the one person to go to who comes back to you very promptly with the correct information.
And it goes back to what I said at the outset of this conversation, Marguerite. Two core key relationships for a business owner are their accountant and their solicitor.
Yeah. And just another question. Only recently I was speaking with somebody, and they said to me, it kind of frightened me because I'm not doing this, that their initial contract is null and void because they've been receiving a salary pay rise every year. Is that right?
That's not right, no. So people get a contract, and in that contract there will be the core terms. A contract can be amended. So if my salary goes from €100 a week to €150 a week, that's an amendment to the contract. It's not terminating the old contract or net rendering null and void. It's simply a change to the contract. Now, where there is a change to the contract, that change should be documented. So there should be a letter or an email or a note to confirm.
So if their job description changes, or to get a promotion, or
it should be documented.
Right.
It isn't always in practice, but there is a requirement that any changes to terms of employment be documented. Or the core terms of employment be documented. So that would be the good practice. But a change of a term of an employment does not render the contract void.
So it's not mandatory?
It's not mandatory.
Okay.
Well, it is mandatory if there is a change in the terms. It's mandatory to document what that change is.
Okay.
But you don't need to issue a brand new contract every time there's a change in the contract.
Perfect. Well, do you know what's actually surprised me from this conversation is, I would have said employment law is a minefield, but what I've learned is I think, regards to me and my business, that, I'm fairly up to date with employment law, and I'd say that's a lot to do with your good self, John.
Thank you very much, Marguerite. It can be a minefield if you let it be a minefield.
Yeah. That's just, everything you said to me resonated with me, so I think I know a bit more than I thought.
If you put your fundamentals in place, when a question arises, you know where to turn to get an answer.
Yeah.
And what I find in what I do with business owners like yourself, an awful lot of the time, people will ring me up and say, this, and this is happening. This is what I'm thinking of doing to deal with it. And 90% of the time I'd be saying, yep, that's absolutely fine. Go ahead. Or I might say to them, yeah, look, that's that's fine. Have you thought about A, B, and C? And we might tweak it a little bit and deal with it slightly differently. And only occasionally would I be saying to people, no, don't do that.
Yeah.
We need to go in a completely different direction.
But it is so important as an employer to have your house in order when it comes to employment law. I learned that a long time ago. You know, it's important that you can sleep easy and everything is in.
When I have a new client on an employment law matter, the first question I will ask them is, can you send me in the contract and the staff handbook? If the answer to that is we don't have one, well, that's our starting point.
Okay.
My experience is when an employer ends up before the WRC, so say an employee has brought a claim against them or a former employee has brought a complaint against them, almost the first question the WRC adjudicator will ask, can I see the contract and the handbook? If the answer to that is, well, we didn't have one back then, but we have one now, you've lost that case.
Okay.
Before it goes any further, you're not going to win the case. It is a fundamental. There are statutory requirements going back many years now to have the documentation in place, and that's where it starts, and that's the building block. Yeah.
Great. Well, look, John, thank you very much. That was very insightful and learning experience for me. You know, I'm very happy that I've learned that. I think I'm up to date with my employment law matters. And for any of our listeners, if you need any more advice on employment law, you can contact John directly at john.lynch, is it?
John.lynch at whitneymore.ie, or all my contact details are on the Whitney Moore website, and we're happy to.
Yeah, we'll have them on our website too. Thank you very much.
Thank you, Marguerite.
Thank you for joining me on the Dental Chair. If anything resonated with you, if you've any queries on your job search, your recruitment needs, you can contact me directly at marguerite@irishdentaljobs.ie, or you can call 01 849 40 70. If you enjoyed listening to this episode, please like and share. This is Marguerite Morgan from Irish Dental Jobs reminding you that people matter. Until the next time, slán agus beannacht.